Hello, class. Can you hear me?
Yes, sir.
Yes, I can. I can see that because of the fact that I postponed the exam, the test last week, the class has reduced into the class has reduced as against what I used to have before 9:30. Now, I think we can start so that they'll not waste my time. And please, I just want to say that I'll prepare for your test by Wednesday, and I will tell you the modalities as we go on. Now, the thoughts, the topic is on still on occupiers liability. And before I go on, I just want a volunteer to do a summary of the background or general overview of what we discussed last week, Wednesday, so that I will know that we are in the same page and that you are indeed assimilated all that we discussed last week Wednesday. I need the volunteer. I don't want to call name, but if you want me to call name, I don't have any problem with that. But let's see for the next 10 seconds. Who can volunteer? Who can volunteer? Don't let me change my impression about your class, please. Emeka Ude, you are laughing. So do a recap of what we did last week in 3 minutes. Emeka Ude, and I want your camera to be on as you are doing that. Class rep. Class rep.
Hello, sir.
Yes, please. Can you help me note the name and material of Emeka Ude? If it's not ready, just.
So I'm speaking, sir. From what I remember, can you hear me, sir?
Yes. Turn on your camera. Turn on your camera. You can't be reading for me from your. Yeah, go ahead.
From what I can remember, was last week, we talk about whereas the occupiers of the land have the disrespect towards those that come to their land.
Your audio is not okay. Go ahead now. Go ahead.
Okay, can you hear me?
Yes, it's better now.
I said, from what I can remember, you discussed the occupiers of the land have the
Alim, can you mute yourself? Alim Adewale. So after Emeka, you take the floor. Go ahead,
Did you get that?
I didn't get that.
I said you discussed last week about how occupiers of the land have a duty of care towards those that come to their land.
Okay, go ahead.
That's what I can remember.
No, that's not so good. I spent an hour 30 minutes with your class, and you only remember only one line from all that I've said. Okay, before I call on Michael, before I call on Michael Benga, Alim Adewale, Abdjalil Alim Adewale. Ayomide, is there anything?
Okay, Michael raised his hand.
Ayomide.
Okay,
that's another Ayomide. I thought it's your classroom. Alim, Jalil, where are you? Class
That's why
rep,
they call it random.
class rep, class rep. Let me note. Alim Adewale, go ahead, go ahead. Just in 1 or 2 minutes, give us the background or the overview of what we did last week. Please, the class rep, can you help me note Unwogu Chinelu? Yes, she has been disturbing our class this morning. 210-060-117. Can you help me note and name and matric number, please? Unwogu Chinelu. I ask all of you to mute yourself. Go ahead. Alim, go ahead. If you don't talk this morning, I may as well just I'll take the class as taking. And so that does not affect me in any way. So if Alim is not talking, Alim, talk now. You are home.
Hello, sir. Can you hear me, sir? Hear me, sir?
Go ahead, please, go ahead. We can hear you.
I'm with you, sir.
Give us overview. Give us give us a recap of what we did last week. Well, please, a class rep, help me note that Alim did not comply with our instruction. So let me call on Michael Benga. Then Ayomide Aladeni, followed by Odwadamilari Bolu. Then we are done. So can you give us a recap of what we did last week, so that we know that we're on the same page?
Good morning, sir.
Yeah, good morning. Please, can you help me to turn your camera on? I want to see my senior students. Okay, go ahead. Go ahead. You can turn off your camera if your background is not good. You can turn off. If your background is not good, but I can't see you. It's dark. Michael, go ahead now. Michael, unmute yourself, please.
Sir, can you hear me?
Yes, clearly now.
Okay. You started the class with reminding us about Lord Atkins' neighborhood test. Then you went on to specify the instruments that were responsible for the occupier's liability. You told us there are 2 statutes that have been actually legislated on that topic. You said there was that of 1957 that has to do with people that enter into a person's land with permission. You say later on there was also a legislation made in 1984 that has to include those that did not ask for permission. You went on to define occupier's liability as the duty of care owners of land or people that have control over land owes towards those people that enter their land. And you specify that at first, this duty was towards people that have permission to step into their land. But after evolution of certain developments, the law decided to legislate on even those people that don't have permission, known as trespassers. And okay, you also defined certain terms. You define who an occupier is. You define an occupier as somebody that is exerting control or that has specific control over a land. And you say there's a reason for making the owner of the land liable. That is you gave a justification for the liability. You say the reason why the person is liable is because he's the owner of the land and is in a better state to know the condition of the land more than anyone else. So if by having control of the land and knowing the state of the land better than anyone else, that person cannot how do I put it in words? Cannot shield or protect those that come into his land from danger, then of course he's liable to them. What else? What else? Okay, you also defined who a visitor is. Yes, you defined a visitor, and you told us that the word visitor is anybody that you gave us different aspects of visitor though, but you also made us understand the fluidity that can exist in that term. You said it's possible for someone that is a visitor with permission to also become a trespasser. That, for example, you gave us a case of trespass ab initio. You also told us that if one enters into a land with permission and that person stays on the land beyond the time he is given to stay on the land, then it can shift from being a visitor into a trespasser. What else? What else? What else did you tell us? I
Michael.
think that is all I can remember, sir.
Yes, Michael. Honestly, that's brilliant. I'm trying to see how I can. Okay, I think I've seen. Yes. Okay. You see my gesture? Have you seen my gesture? Okay. Have you seen my gesture?
Yes, sir. Yes, sir.
Okay, great. So that's brilliant. That's brilliant. So
Thank you, sir.
it means that I'm not talking to I've not been talking to myself alone. So then let's see what Oluwadamilare Bolu have to say.
Hello, sir. Good morning, sir.
Yeah, good morning. Then a class rep, please. Let me note the names of 3 volunteers. Ayomide, Oluwadamilare, and Michael. Let me know their names and my number. Okay.
All right,
Hello,
sir.
sir. So I'll
All right.
just be talking. I'll just be talking about the 4 categories of occupiers that you mentioned last week.
Okay.
And you said that this was established by Lord Denning in Witt's case, where he identified 4 categories of occupiers. The first one is a landlord who lets out premises. That means the landlord has parted with control of the premises, so the tenant will become the occupier and then becomes liable. The second one is a landlord who lets out parts of a building, but it remains other parts, such as common areas, such as maybe a common staircase. So in this scenario, the landlord still remains as occupier of the building that he has retained. Then you also mentioned that the third category is where a landowner licenses a person to use a premises, and then the owner has a right to enter on the premises to do repairs, and he retains control and is also still the occupier. Then the fourth one is where an independent contractor is employed to do work on premises, and then the owner would generally retain sufficient control to be an occupier. But it is possible that the contractors will also be occupiers in this scenario. But this actually depends on the amount of control that they have while the work is in progress. So in the fourth scenario, the liability of the independent contractor depends on the amount of control that he or she has, or that such contractor has while the work is in progress, to become, an occupier, or to be liable as an occupier. Then you also talked about the highlights of situations of occupation. It can be landlord and tenant, can be multiple occupancy, can be vicarious occupancy. And I think you also mentioned that, under premises, although there is no statutory definition of premises, but in ordinary parlance, it can mean houses, it can mean buildings, it can mean structures, places of, different sorts, as like on which people can be invited to come into, or to come on. Yeah, that's what I remember, sir.
Oh, great. That's another brilliant recap. Then I've also given you my own gesture by sign. So then that's Oluwadamila. It's Oluwadamilare.
Yes, sir.
Oh, okay. So can you also turn off your camera? Let me see. So that if I see you on the road, I won't be saying who is this person. I think where you are, your background is a bit your background shows a bit of sunny. Okay. All right, perfect. So, class rep, let me note her name as well and her matric number. Okay, then last person, I think lastly, we have Ayomide Aladeniyi. I may also take Obasa at least for indicating. So Ayomide Aladeniyi, you have the floor.
Good morning, sir.
Oh, good morning.
Okay, from what I remember from the last class.
If your background is good, can you turn on the camera if it's good, but if it's not good, then you can just go ahead. Okay.
So from what I remember from the last class, you spoke about occupier's liability, and you said it's like connected to negligence because there's a duty of care, and an occupier owes a duty of care to those who come into his premises. And you said there are two acts. The first one is the Occupier's Liability Act of 1957, and this one applies to an occupier towards those who come into his premises with permission, and the one of 1984 applies to those who do not come in with permission. But Nigeria's own law, Nigeria's own Occupiers Liability Act, is patterned after the one of 1957 as a result of our colonial history. And you also noted that there must be like sufficient control on for someone to be termed as an occupier, or for someone to be liable to people who come into his premises. There must be sufficient control on the part of the person. And then you noted that both occupiers, trespassers, lawful visitors, they are not actually defined by statute. But then from cases, from common law, we can actually state what they mean. And you said that lawful visitors, the definition of lawful visitors is a matter or a question of fact. So each case differs. And I remember you saying that a lawful visitor can become a trespasser, and then a trespasser can become a lawful visitor later. And you gave the instance or scenario of canvassers. And okay, the last thing, you said that at common law, there was the distinction between invitees, licensees, and contractual visitors. And you said that the distinction is no longer relevant because that was what, the act sought to, that was part of the things the act sought to, like take away. But then you said like we can note it for introductory purposes and for background purposes. So an invitee is invited by the occupier, and his presence would bring some form of material benefits to the occupier. And a licensee, the person's presence might not bring any form of material benefits to the occupier. And then a contractual visitor is someone who comes in for contractual purposes to maybe to perform a contract and all that. So that's what I can say.
Okay, great. I've also extended the answer of gesture by clapping for you. I think that's also a brilliant recap. Then finally, let me take on Obasa. Class, how we are noting the names of those that have called.
Yes, sir.
So those are volunteers, not Kalu that I caught on the screen. So Elizabeth.
Yes,
Obasa,
sir. Yes, sir. Good morning, sir. So
good morning.
I'd just like to buttress some of the part that my other colleagues did not mention about who a lawful visitor is. You also said that a lawful visitor can be somebody who has rights of way. That when somebody has already maybe had some right of way on the premises, is also being considered as a lawful visitor. Then the definition of premises can simply put houses or building. The case of indemnware and dames, place or structure of such which person may be invited to come. Also, Section 6 sub 3 of Law Reforms Act enumerate fixed movable structures and vessels, vehicle, aircraft as things capable of occupation as being a premise too. So Section 9 of Lagos Law Reforms also says that a premise include fixed and movable structure is also a premise?
Great. I think so that I won't be partial. Let me also give you the sign. I think I'm done with all the volunteers. Elizabeth, can you also show your turn your camera on so I know who you are? I won't be talking to AI. Okay, yes, great. All right, so I think that will be about it. By the grace of God, very soon, when you resume fully, I mean, when you resume physical lecture, we are going to know ourselves very well. Now, I want to commend the volunteers that have helped us to put our last week discussion into a proper perspective, and it shows that you pay adequate attention to the lecture despite the tension that was coming your way when you thought that you were going to write your test last week. So I think that's suiting for me. And if you could aggregate these your positions in the exam, I don't see a reason why you should not be competing for A's in TOTS, and that's the truth. I'm not flattering you. And that's solidified the impression I have about your class, and I still maintain that. And I hope that impression will not change going forward. So, having said that, my task this morning has been simplified by your interventions, and just to comment some cases to you that will guide your reading as well. And before I give some cases, or I can use my disclosure to also point out some cases for you to note. Now, let's look at. I think, let me see. Can you all see my slide, or I should reshare it because of those that came late? Maybe let me see if I can reshare it.
We can see your slide, sir.
Okay, some came very late. Okay, so now, yes. Okay, so if you look at our overview, I said we shall be looking at the occupar's liability, the nature and scope, which you have also recap, introducing the principles of the thought of occupar's liability. Then we always look at the statute-based liability, trespasser, the common duty of humanity, liability for the act of independent contractor, defenses, remedies, among others. Now, yes, we have looked at the basis, and I've also advised that you should note the fundamental question about whether the defendants had the sufficient degree of control over the premises to put them under a duty to a visitor. And of course, we have also looked at the definitions of premises, and I think we need to go back again on those aspects. Then the case of Manny and Scott that I give you, contrast that with the case of Letic and Ovic. So then I also provided section 9 sub 2 of Lagos State Law Reform, Tort Law 2013, which said that premises include fixed and movable structures. They are also going to look at the savings provisions of that particular law. Now, the question as to who an occupier is has been well defined, and especially I have to look at the case of Iris and the Backing Aid Corporation. Now, in that particular case, now a compulsory purchase order had been served on a house by a local council with a notice of entry which allowed the council to take over the premises 14 days later. Now, after the resident had moved out, the council failed to board up the house. Now, the claimant, a 4-year-old child, got into the house through an unsecured door and ended up falling from a second-floor window. The Court of Appeal in that case held that the fact that the local authority had the legal rights to control the premises made them the occupiers and excluded the previous owners from any liability. The local authority was in the best position to prevent any accidents. Now, what this particular case tell us is that, link clear to the fundamental question of whether the defendant had a sufficient degree of control over the premises to put them under a duty to a visitor. Now, if you look at that particular case of Iris, I'm sure when you read further about that particular case, you can dissect the principles, the rationale behind the courts coming to that conclusion to hold the local authority responsible. Now, let's look at the fact again that a compulsory purchase order had been served on a house by a local council with a notice of entry which allowed the council to take over the premises 14 days later. Now, after the residents had moved out, the council failed to board up the house. Now, the claimant, which happened to be a 4-year-old child, got into the house through an unsecured door because the apartment had been left open. So, through an unsecured door, and ended up falling from a second-floor window. In the wisdom of the court held that the local authority had the legal right to control the premises because they have not taken over by implication. So this laid credence to the degree of control that I'm talking about. Then now, in some situations, there may be more than one occupier, which I also mentioned last week, in which case both or all can be liable in respect of the same damage. So, and I think Bolu talked about the multiple occupation. So, for example, a landlord rents a whole building to one tenant. Now, the tenant is the occupier, not the landlord, if he occupies the entire premises. However, if the landlord retains possession of parts of the building, such as a common staircase, or has a right to enter the premises to do repairs, both the tenants and the landlord will be occupiers at the same time. So do not be carried away by someone being the owner of the property or someone being has exclusive occupation of the premises. Once there is a tendency to share the occupation of premises, then there will be multiple occupiers. So now, I want to advise this class strongly that you look at the facts of the WIT and Il Lecon Company Limited that I gave you last week. Now, it was Mr. Witt that actually sued. It was the claimant in this particular case. Look at that fact of that particular case. It's a very lengthy fact. Look at it very well. Dissect the principles as discussed by Lord Denny also discussed in that particular case. Then you have Salman's opinion in that particular case as well. Look at what he said about that particular case. Now, on the face of it, the court held that the respondents were not liable. The court held that both the manager and the owner of the premises were not liable, and it was one reason that led to that conclusion. But if you read the particular case from beginning to the end, you will discover that if I'm able to be a judge in that particular case, I'm going to hold the occupier and the occupier liable because although for 20 years of existence of that particular guest house, there have not been any case of hazard, okay? And it was the act of a stranger that led to the claimant's injury. It was the act of a stranger, and it was on that basis that narrow fault of a stranger that I made the court to absorb the defendants from liability. Now, that particular case is very important to me, and that's why I'm being stingy in coming out with the entire fact. But what I can just tell you is that for most of those who have not read that particular case, in that case, the defendant owned a public house. It was run by a manager and his wife. So the manager and his wife were Mr. Richardson and also Mrs. Richardson. So, and they both lived on the first floor of that particular public house. Now, and they were allowed to take in paying guests. Now, the manager lived on the first floor because of his status as an employee. Now, not as a tenant. Please know that, not as a tenant, but because of status as an employee. So that service occupancy. Now, a paying guest was killed when he fell on the emergency staircase while trying to get to the bar on the first floor. Now, there's of laws held that both the manager and the owners were occupiers. But on the fact neither was held to be in breach of duty, the bad lighting on the staircase was caused by a stranger removing the bulb, and they were not responsible for the stranger's actions. So now the reason for holding that they were not liable, despite the obvious the findings of the court saying that they were the occupiers of the premises, was predicated on the fact that the findings that it was a stranger that removed the bulb that lighting the stairs. So on that note, they were not responsible for the stranger's actions. So the court felt that the act of stranger was an independent action. So note that particular case very well. Now, you can also look at the case of Bailey and the Arms or Ames. It's spelled Bailey versus Arms, Armes. Now, in that particular case as well, the defendants were a couple who lived in the flats above a supermarket where the husband worked. From one of their windows, it was possible to gain access to a flat roof. They allowed their son to play there, but had forbidden him to take any other children onto it. Now, the supermarket owners owned the roof, but knew nothing of the fact that the child was allowed to play there. One day, he disobeyed his parents and persuaded the 8-year-old claimant, who was a friend of his, to climb up onto the roof from the garden. Now, the claimant fell from the roof and was injured. He sued both the couple and the supermarket owners, but the Court of Appeal said that none of the defendants could be considered occupiers because they did not have a sufficient degree of control over the roof area. So, also look at the reason for holding that they were not liable. Please still refer to my earlier question whether the defendant had a sufficient degree of control. That should always be your guiding angel when you're answering questions on occupiers' liability. Who has sufficient degree of control? Now, you can also look at the case of Revu versus Newberry, which is REVILL versus Newberry and Newberry. That's NEWBERY. It was also reported in 1996. Now, so I will not waste our time on the fact of cases. I'll read them very well. So this will support, or this will highlight or enhance your understanding of who an occupier is. Okay, so having said that as well, before going into who is a visitor, let me go back to my slide to see what I've missed out. Okay. Okay, I've mentioned Aris and the Backer Corporation. I've also mentioned WIT and ILACOM. This WIT and ILACOM is very important when you discuss occupiers liability. Okay, yes. I think I'm okay with the definition of occupier that I've given. Then with other discussion that we had last week, the 4 points noted by I think Elizabeth, please master those 4 grouping of occupier. Okay, so where a landlord lets premises by demise to a tenant, what is the implication of that? Where an owner lets floors or flats in a building but did not demise the common staircase, what is the implication of that? Where an owner did not let premises to a tenant but only licensed the person to occupy them on terms, what is the implication of that? And the 4th one is that we are now employ an independent contractor to do work on premises or a structure. What also the implication of that as to, on who lies the burden of the duty of care in that situation. So, if that permits, I also come to that. I want to see how far we can go today. Considering that you have given me a hope that you understand all that I've been discussing so far. Now, I also advise that you look at the case of Fairman, and let me type it for you. The case of Fairman, you can look at your chat box. In the case of Fairman and Perpetual Investments Building Society. Okay, so also look at that case as well. It will also give you understanding of shared occupation, what it's all about. So in that case, shows that a landlord, by retaining control over the entrance and common staircase in a block of flats, is regarded as the occupier of those parts. So I'll read through that particular case as well. Now, let's now go to lawful visitors. And let's look at the instances of the lawful visitors. Now, just like I mentioned last week, that the question as to who is a lawful visitor is a question of fact, depending on the circumstance of the case. And I gave some instances of when someone will have an implied someone that has an implied permission regarded as a visitor, and also give the one that has to do with operation of law, that is persons entering premises as of rights are lawful visitors. So I give example of section 676 of the NEPA Act. Then really the case of boating and stone that you already have in your according for proper understanding of an implied permission. Then lorry and worker. If that permit, I will still discuss the case of lorry and the worker. So now instances of the visitor. Now, not every of visitation, not everyone who goes on to someone's premises does so as the occupier's visitor. Now, if B enters premises occupied by A, B will do so as A's visitor if 1, B was invited or permitted to enter those premises by A, or 2, B was invited or permitted to enter those premises by someone who had the ostensible authority to issue such an invitation or permissions on A's behalf. So we look at these points as we go on. Now, the point of visitation I'm talking about is that it's not everyone that goes onto someone's premises that does so at occupiers instance. Okay, but where B enters premises occupied by A, for example, B will be do so as owner, as A's visitor. If B was invited or permitted to enter those premises by A, or two, where B was invited or permitted to enter those premises by someone who had the ostensible authority to issue such an invitation or permission on A's behalf. So, the case of Ferguson and Wells explain this as well. Now, on the second point, after visitor, I'm talking about the instances of visitation. Now, on the second point is what we call estoppel. Now, it will generally not be difficult to establish whether from point 1A or point 2A above are true. But even if they are not, A may still be prevented or is stopped from denying that B entered his premises as a visitor if he or someone with ostensible authority to act on his behalf reasonably led B to believe that A had invited or permitted her to be on those premises. Now, I look at the case of Edwards and Railway Executive, where the court said that he considered the question whether a license can be inferred. The state of mind of the suggested licensee must be considered. Now, does he knows that he has a legal right to enter the premises as invited by the occupier, or does he just stray on his own to the property of the occupier without the occupier's permission? Now, the circumstances must be such that the suggested licensee could have thought and did think that it was not trespassing, but was on the property in question by the leave and license of its owner. So that point now takes us to the case of Lorry and Walker. And in that case, where members of the public had for about 35 years taken the shortcuts across the defendant's field to get a railway station. In all that time, the defendant never started legal proceedings to try and get people to stop crossing his field. The House of Laws found that by acting in this way, the defendant had led members of the public to believe that they were permitted to cross his land to access the railway station, and could not therefore now argue that they were trespassing on his land when they cut across his land for that purpose. So that can be an ostensible authority. That's one. Then also, if someone had been led to believe that he had permission to enter the premises of the occupier, okay, and he did think that it was not trespassing, but was on the property in question by the leave and license of its owner, then he cannot be regarded as trespasser. What that simply means that the occupier has a duty of care towards those persons who find themselves on that land. So, and the case of Lorry has explained that. So, also, another instance of lawful visitation is persons lawfully on the premises, which is to the effect that Section 2, for example, of the Occupiers Liability Act of 1957 provides that the common duty of care that an occupier of premises owes his visitors will also be owed to someone who enters the premises in the exercise of the rights conferred by law. So, and I've also discussed these instances last week, but just to bring our discussion to bear, these situations cover the police. I mentioned that it covered the police. I've also mentioned that it covered the emergency services, such as fire or ambulance crews, and other statutory regulators. So, if someone performing a statutory duty enters the premises of occupier without the occupier's notice or permission, then they will be deemed to be they'll be deemed to be exercising their right under the law, and so they are protected by the Occupiers Liability Act or statutory provisions provided by relevant relevant compatibility law or act, as the case may be. So I give example of Section 7 of the NEPA Act, okay, which enables the NEPA officials to enter premises to inspect the meters and ancillary properties of the NEPA on the premises occupied by the occupier. So what that simply means that the occupier has a duty to ensure that his property is not left in dangerous states, so that those that are not specifically invited, but that their invitation, but that their presence on your occupier's property will be deemed to be proper based on the right conferred on them by law. The occupiers need to ensure that his property is not left uncatered for. So now, on the sort of premises, you can look at the case of atom leasing and cogniting 2004, where the claimant was a mature adult. The court said that the message of the lake did not pose any kind of danger to a mature adult, but that's for a child. It might have been different if the claimant in Tomlin's case had been a small child who fell into the lake and was injured. So the degree of responsibility will be different. When the court put the age into consideration to hold responsible the occupier or whose premises are in a dangerous condition. So now I've also identified some points that will guide you on when common duty can be breached. Okay, duty situations and when it can be breached as relates to occupiers' liability. Now, look at this point on the children. The occupier has greater responsibility towards a child than a mature adult, as seen in the case of atom leasing and cogniting. So then also no risk. I'll come back to all these points as we go on. Now, no risk as well. Two provisions in Occupiers Liability Act of 1957 reflect this point. First, Section 2 sub 3 of B provide that an occupier may expect that a person in the exercise of his calling will appreciate and guard against any special risk or daily incident to it so far as the occupier leaves him free to do so. Now, if you are independent contractor, for example, or you are a man of high degree of sense, okay, you should be able to guard yourself against risk when you are visiting the premises of an occupier. For example, a carpenter, artisans working on the premises of an occupier will have a degree of knowledge as to how to guard themselves against risk. Okay, so unlike a child who is visiting a premises, then also there's another point we call accepted risk. Okay, some of risk which you call voluntary non-victim injuria, we apply in some cases, and I'll give you the case of a Sims and Le Rugby football club. If you permit, I'll go after this one after the other before I give you some tips on defenses. Now, on independent contractor as well, I've also discussed that for independent contractor, what you need to know is that an independent contractor, being one who undertakes to execute a job and who for purpose of such execution is not under the control or order of the person for whom he does the work for. So he also has a degree of knowledge to ensure that he guard against risk. that will put him into imminent danger. Now the question that arises is, what is the liability of an occupier for the acts of an independent contractor in view of the fact that he, the occupier, cannot determine how the contractor performs his work? Now, in fact, the occupier is more likely to set up the act of such contractor as a defense to an action for damages for injury sustained by a lawful visitor on his premises. Now, on this, you can look at the case of Asidin and Sea Laws and Sons Limited. Also look at the case of Thompson and Akremi. All these cases point to the fact that the occupier will not be regarded as insurer, where an independent contractor ought to have known that a certain risks are imminent in the premises of occupier. So the common position with regard to the liability of the occupier to an invitee, for example, for injury suffered from the act of an independent contractor seems unsettled. But if you look at the degree of control that I mentioned earlier, that confusion can be cleared. So, and I want you to look at the case of Asedin and the Sea Law and Sons Limited. The Asedin is spelled Haseldine, and the Sea Law and Sons Limited. So that case with the case of Thompson and Akremi explain the in what instances can the occupier be liable to independent contractor on the premises. You can also see the case being displayed on the screen. G. Williams and West Artificial Hospitals NHS Trust for further information. Now, before I go into a trespasser, okay, of course, we have said that invitee, contractual, visitor, licensee are now seen as lawful visitors under the Occupability Act of 1957, and also the law that followed in England, which is the Occupability Act of 1984. But why I'm not digging so much about the Occupability Act of 1984 is because of the fact that we now have our own law, which is Tort Law Reforms Law of 2013. Elizabeth, your hand is up. Elizabeth.
Hello, sir. Good morning, sir. Please, I have a
Yes.
question.
Okay.
Under this list,
Okay, go ahead.
okay, thank
Under
you, sir.
what?
Under this list you gave us, considering breach of duty under the Act, please, I don't understand it very well. Are you saying that the occupier would not be liable under this instances you gave to us, or this is when it will be considered as breach of safety to the
what I'm saying is that I'm just giving specific points to know that we help you to establish whether a commodity of care has been breached. Hello, Elizabeth, can you hear me?
Yes, sir, I'm listening.
Yeah. So I'm not saying that they won't be liable, because I just give you. I don't. I need to time. I don't want to go into each heading. So there are a lot of instances where to find out when the occupants will be liable or will not be liable under common law is easier. Okay, but now the law has given us some tips on how to determine whether an occupier will be liable or will be said to have breached the commodity of care. So I just give you different headings that look at the heading on children. In what instances can the occupier be absolved from liability as relates to a child? Because I have to leave class by 11 p.m. 11 a.m. That's why I'll be careful not to bear so much. Now, Osarien, before, so I can conclude on these thoughts. Osarien.
Okay, thank you, sir. Sir,
Right.
please, can you hear me?
Yes, go ahead.
Okay, sir, under independent contractors, sir, you mentioned two other cases. Sir, please, can you come again? I could not really get them.
Under what?
Independent contractors, when you're talking about their liability.
Yes, I mentioned the case of Asdin versus C Law and Sons Limited. And I said it's spelled Haseldine. Haseldine. And C Law and Sons Limited. Okay. Then another case I mentioned is Thompson and Cremy. Thompson is spelled Thomson, and Cremy is spelled Cremin. Yes. So all reported. The first one was reported in 1941. The other one was reported in 1953. So now I'm not saying that occupier will not be liable as regards so that no, that occupier will always be liable when as regards the children, but I'm saying that the fact of this case will determine whether they will be liable. And the first question that I wanted to ask you now that you brought that up, and let me just quickly say this under these points that will guide you whether a duty of care has been breached. Now, I want to give you an assignment, and that assignment is not to be graded. Please note that it may not be graded. Let me use the word it may not be graded so that will make you do it. The word it may not. So I may try to use it as part of your CA, and I may try not to use it. Is that look at that there are instances even on the liability of occupier to children coming onto his land. There are instances whereby the occupier will not be liable where there's been certain pointers to show that his premises is not safe, is not currently safe, or it confines his visitors to certain limits, so that when they slip for that limit, then he will not be liable for whatever injury that occur in the area where the visitors were not permitted. Okay, so now and this is also true when we talk about general law of negligence. Now, under which an occupier will owe a variety of people a range of duties of care. For example, to his visitors, a new duty, which we'll be talking about, to take reasonable steps to protect them against being harmed by fellow visitors. On his neighbor, to his neighbors, a duty to take reasonable steps to abate hazard arising on his land that threatens to damage his neighbor's land. And also to people passing by his land, a duty to take reasonable steps to avoid their being injured as a result of any features on his land falling into the road outside his land. Please note this. Please note this 3 points. Now, I said that even under general law of negligence, under which an occupier will owe a variety of people a range of duties of care to his visitors. Now, this means that to take reasonable steps to protect them against being harmed by fellow visitors. So you can have some visitors who are on your land at the same time with other visitors, and those visitors will now hurt another visitor. Now, if you have done vacant liability, you will know instances where an employer will be liable for the tort committed by employee. So the defense of common employment will not work to say that I was not the one that committed I was not the one that caused the injury. It was my employee that caused the injury. The principle of accountability will take care of that. Now, the same way as when you have visitors on your premises, you invite visitors on your premises. Please, this answer the question raised by Elizabeth. So, on this of common duty of care, when it can be said to be breached. So, no risk, and also a certain risk. Now, so if you bring some visitors to your land, and some of the visitors cause injury to another visitor or to other visitors, the occupier may still be liable depending on the scope of that invitation. Now, 2, to his neighbors, a duty to take reasonable steps. A duty to take reasonable steps to abate hazard arising on his land that threatening to damage his neighbor's land. Please give me 1 second. I just want to scroll down all this. Now I was saying that to his neighbor, a duty to take reasonable step to abate hazard arising on his land that threatens to damage his neighbor's land. Now, also to people passing by his land, a duty to take reasonable steps to avoid their being injured as a result of any features on his land falling onto the road outside his land. This last leg can also be useful for the case of lorry and worker that I mentioned earlier. Now, an important issue is whether an occupier of land can rely on a notice, and that's where I'm going. Now, notice can help reduce the damages that will be advanced by the courts to a claimant who has successfully proved his case before the courts. Now, whether he can rely on the notice he has put up on his land to escape being held liable to someone who has been injured on his land. Now, to address this issue, there's a to distinguish between 3 types of notice. The first type is what's called a disclaimer notice. This disclaimer notice make it clear that the occupier does not accept that he has any duty to look out for the safety of people in his land. Now, example of such a disclaimer is when you see a notice like this: no responsibility accepted for the safety of people or their property on this premises. That should warn you off of that property. That should warn you off of that property. Now, the second type of notice is what we call an exclusion notice. The first one is disclaimer notice. Don't come to my property. The second one is exclusion notice. Exclusion notice here is where the occupier accepts that he has a duty to look out for the safety of people on his land, but put people on notice that if they want to come onto his land, they have to agree that they will not sue him, or only sue him for a limited amount of money if he fails in that duty and they suffer harm as a result. A good example of this second leg is when we say no liability accepted to anyone suffering harm on this premises. We put notice like that. No liability accepted to anyone suffering harm on these premises. Now, so that can also be a case of a volunteer non-fit injuria. The last one is a warning notice. Now, warning notice, you are simply telling people coming onto the occupier's land of a particular danger on that land. An example of a warning notice is you see a big inscription on your door or on your premises saying that risk of death or injury beyond this point. I've seen that a lot. When you go for picnics or you go for tourism, you see certain area they'll put that risk of death or injury beyond this point. So if the occupier has put all these designs, okay, what that simply tells you is that for lawful visitors, though, not for trespassers, for lawful visitors, then they have to ensure that they don't go beyond or they keep to the terms of the notice. On this point, I want to give this assignment just one half page assignment or 2 page assignment, and it should be based on disagree between 3 types of notices: a disclaimer notice, exclusion notice, and warning notice. Disagree between a disclaimer notice, exclusion notice, and warning notice. Okay, so on that one, I give you that you only have that to submit between now and Wednesday on that one. Just explain your understanding of disclaimer notice, also warning notice and exclusion notice as regards to limit of liability of an occupier. Okay, Elizabeth, your hand was up before I give the assignment.
Yes, sir. I did not understand what you actually said under exclusion notice. I only heard the term you mentioned that where the occupier state that he has no liability to anyone that suffered injury on the land, but it's looking quite similar to disclaimer notice.
Yes. Now, I've not given an assignment to go and help us to distribute between the three. I want to give you a general understanding of what it's all about. Now, for exclusion notice, is that occupier accepts that he has a duty to look out for the safety of people on his land. Okay, but also put out notice that if they want to come to his land, they have to agree that they will not sue him. So this is like a case of voluntary non-fit injuria. So it's limited his liability to the visitors that if you come to my land and you suffer harm, you won't be able to sue me. So, and I give you an example that if you put a sign to say no liability accepted to anyone suffering harm on these premises, that does not mean that the court will not still award damages against the occupier, but the amount of damages that will be awarded will be at minimal cost. So that's for exclusion notice. Okay, but for the disclaimer notice, okay, the occupier does not accept liability at all. He does not accept that he has a duty to look out for the safety of people on his land. And so he clearly put it there that no responsibility accepted for the safety of people or the property of these premises. That means you bear whatever risk involved by coming onto my property. What that simply means that by implication, you're also being warned off that do not come on these premises. So, but your discussion will also help us to better understand these three concepts as I've given you. Just do your assignment and I'll bring it to class on Wednesday. So I'm going to say I'll send you an email that you forward it to. Okay. So then having said that, so let's now continue from where I stopped. And that has to do with establishing a duty under the Acts. Okay, now for the first one, so I've used those scenarios to explain this. Look at the liability of occupier to charge a visitor. Okay, then look at the point of no risk when someone is aware of a risk and he ought to have guarded against those risks based on skills and expertise, whether the occupier will still be liable to that person. Then also look at the provision of section 2 sub 4 of the Occupiers Liability Act of 1957 as well. Then you can also look at the accepted risk, voluntary non-fit injuria that I mentioned. Then finally you look at occupier of independent contractor under this heading. Now, let's now go to trespasser. Let's go to trespasser. No, so I've also discussed that a trespasser is a person who goes on land without invitation of any sort and whose presence is either unknown to the proprietor or to the proprietor of, if known, is practically objected. So you look at the case of Adi and Sons Dumprig, which says that any entry contrary to the wishes of the occupier is a trespass. And also, here I've also discussed the liability of trespassers or to trespasser, that whether any duty is owned by an occupier of premises to non-visitors in respect of any risk of their suffering injury on the premises by reason of any danger due to the state of the premises. Now, so the phrase duty of common humanities is what has been used to find that the occupier is also has a duty towards trespasser, and this does not come until 1972 or 1972. Before 1972, the occupier only owes a minimal duty of care, a minimal duty of care to trespassers. Okay, only owe a minimal duty of care to trespasser, and so the liability of an occupier to trespassers on his land falls under the law, the Law Reform Tort Act, and remains governed by common law principles until 1972. So the rule was that an occupier owed no duty to trespassers other than a duty to refrain from deliberately or recklessly causing harm to them. So, for example, you will be liable to a trespasser who was injured by a man trap. Okay, you set a trap or you set up a spring gun with the intention of injuring intruders, or by the reckless blasting of rocks in a quarry. So, but he will not be liable if a trespasser fell down on a dangerous well, or pit on his land, or was electrocuted on some dangerously exposed electrical wires where those hazards were not created or deliberately put there. So that is the principles of common humanity. So the law is that before 1972, before the case of British Railways Board and everything came, the occupier only holds a duty of, or a minimal duty of care towards trespassers. And like I said, this duty is to the fact that occupiers should refrain from deliberately or recklessly causing harm to trespasser. Because someone is a trespasser, you now create you dug dungeon for the trespasser to come in and being injured. In that situation, you'll be liable. But even at that, in 1972, when the case of British Railways Board and everything came, the court came out with a duty of common humanity. Okay, so that's whereas an occupier does not owe a duty of care to trespassers, he does owe a duty of a common humanity. So, or a duty to act in accordance with common standard of civilized behavior. So this, according to Lord Pearson, means that if the presence of the trespasser is known to or reasonably to be anticipated by the occupier, then the occupier has a duty to the trespasser, but it is a lower and less onerous duty than the one which the occupier owes a lawful visitor. So it's normally sufficient for the occupier to make reasonable endeavors to keep out or chase off the potential or actual intruder who is likely to be or who is in a dangerous situation. So that's what the law says. Now, you should ensure that you maintain your premises, you keep your premises safe, and that is a normal duty owed to a trespasser. Now, the erection and maintenance of suitable notice board or fencing, or both, or the giving of suitable oral warnings, or the practice of chasing away trespassing children usually constitute reasonable endeavors for this purpose. you know that you have barbed wire wired around your premises. All you need to do is to put proper notice in conspicuous places to say that beware of danger. So you see family or persons putting notice on their board saying that beware of dog, beware of that. So this is to show, is to absorb the occupier from liability in case someone still stray despite these notices. Now, if the trespasser, in spite of the occupier's reasonable endeavors to deter him, insists on trespassing or continuing his trespass, he must take the condition of the land and the operations on the land as he finds them. So it's like eggshell principle. Have you done eggshell score principle? I don't know. A class, have you
Yes,
done
sir.
eggshell?
Yes,
So
sir, we have.
okay, so it's like saying that take your neighbor or take your victim as you find him. So you must also take the premises the way you find it if you trespass, and cannot normally hold the occupier of the land or anyone but himself responsible for injuries resulting from the trespass, which is which is his own wrongdoing. So if you stray on that property, despite the notices, despite what the occupier has put in place by way of safeguards, by way of notices, then the occupier will not be liable at all. So please note that it was on 1972 in the leading case of the British Railways Board and editing that a principle of the principle of common humanity was appropriated, and it's to the effect that the occupier also owes a duty of care towards trespasser, but that duty of care is minimal, unlike duties owed to the lawful visitors. Now, there's one particular case that I also want to give in this under this particular principle. I think I'm trying to remember the case of aside from this case, Addis and Don't Break and the British Railways Board and the NEC. Can someone remember that case? Those that have been reading. I don't know if you have that case. Some of that have been reading. So because that case is also very important for our discussion. For those that have been reading. Oh, okay, yes. I think it's the case of yes, I know the case now. The case of Ugochukwu and Unipetro. How many of you have come across that case? Ugochukwu and Unipetro. How many of you have come across that case? Ugochukwu and Unipetro? No, please, I read those cases very well. Adi and Dombrick's case, British Railway Board and anything, then Ugochukwu and Unipetro. Please, cases that you have been given by your lecturers in class, pay attention to them before you also do your own personal reading and spice those cases that you have already with the new cases that you come across. This will help you to do well in the exam. If I'm giving entirely straight cases that I've not given you, it will be difficult for you to have your full mark. It will be difficult for you to have a full mark. Okay, so that your case will not be that somebody is just marking your script based on the principles that you supplied. So then, having said that, I think we have discussed 4 categories of occupiers. I've also given the justification of liability in occupiers liability. Then we have discussed state of occupation, landlord and tenant, multiple occupation, vicarious occupation. Okay, yes. I've already discussed this one as well. So now our duties established before you talk of breach. So look at section 2 of Occupiers Liability Act of 1957, which provides that an occupier of premises owes the same duty, the common duty of care, to all its visitors, except insofar as is free to, and does extend, restrict, modify, or exclude its duty to any visitor. So I've explained this: extend, restrict, modify, exclude its duty to any visitor by agreement or otherwise. So note that the common duty of care is a duty to take such care as in all the circumstances of the case reasonable to see that the visitor will be reasonably safe in using the premises for the purpose for which he is invited or permitted are permitted to be there. So on this point as well, I would say advise you to look at your general principles in negligence. In negligence, they are talking about factors to be considered. Will be the nature of danger. Okay, how long it has been there and its extent, the cost and practicability of steps required to avoid the danger. You should remember all those principles in negligence. So, and the probability of injury, seriousness of the harm, and so on. Please, all these are very important when you talk of the duty of care that is expected of from the occupier. Okay, so now on this note, I'm going to give you a final case, which is the case of Sawyer and Simons. Sawyer is spelled Sawyer, 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 Sawyer versus Simons, Simonds. Udo, you raise your hand. Udo?
Yes, sir. I have a question, sir.
Okay, please go ahead. We have 7 minutes.
Okay, if I understand clearly, sir, I want to confirm that, of course, there's a common duty of care. But
Yes.
based on this section 2, does it mean that it can be restricted, including with regards to children trespassers?
Yes, very well, very well, very well. And that's why all those notices, you know, my challenge is my time. So I maybe what I'm going to do is that, please remind me that I want to give discuss the situations as regards those fragile visitors, children, maybe those that will need assistance to be guided around your property. Okay, the physically challenge and all that. So I can discuss that when I'm taking my tutorial. If possible, I want us to conclude this part by next Wednesday. By next Wednesday, we'll do our exam or our test, or maybe after the test. So our test will not take more than 45 minutes, and so we take 45 minutes. We take the next 45 minutes to conclude. So now, and that's why I give the assignment that look at the disclaimer, exclusion. All this you have other section 2. And if you look at tort law reform, Lagos tort reform law of 2013, most of these are also there. So like I mentioned, most of our law are patterned after the British law. Okay, and luckily the Private and Property Law Department, University of Lagos, was instrumental to the passage of that law, that tort reform law of 2013. So you can see all this common duty of care is also there. So now the visitors are allowed to exclude, so to limit their liability. So, and that also extends to liability as relates to even the trespassers as well. So though there's common humanity, there's a bit of common humanity, but when you put notice, conspicuous places, you put notice that nobody should come near your property, and you dare the occupier as a trespasser, you dare that what is this man keeping in these premises? Let me go and see what he's keeping there. Okay, so then you'll be absolved from liability as occupier. So, and I also mentioned that the fact of the case will determine the extent of liability. So, and please keep that in view. So, you're able to finish your slide before Wednesday, I'm going to send it to you. But one thing that for me, I see that based on what I've discussed so far, there is no so much that you cannot read some of this principle on your own, as we explained. And please, I'm one some of you that rely heavily on Kodli and Aluko. If you look at the provisions of Kodli and Aluko, they are based on the provisions of tort law reforms law of 1961. So not 2013. So look for 2013 law and see the equivalent sections. Okay, that also define premises, define a visitor, define at least give a clue as to what we mean by visitor, what we mean by occupier, what we mean by premises, and so on and so forth. So I think, and I would also like to mention that merely to give a warning to the visitor of existence of a danger, we know itself absorb the occupier, unless in all circumstances the warning was sufficient to enable the visitor to be reasonably safe. So, as some of you give them warning, you ensure that warning is sufficient. Unlike these exclusion clauses that you see on your receipts, whose bought are not refundable. Meanwhile, it's very tiny. If you do a tiny warning, that may not be enough, okay, to absorb you from liability. So, and when the injury to the visitor was caused by the faulty execution of any work, maintenance or repair by an independent contractor, we have said that the occupier will not be liable only if he acted reasonably in entrusting the work to the contractor, and he took reasonable steps to satisfy himself that the contractor was competent and that the work had been properly done. So if you hire a quack contractor, you still be liable. You still be liable. So now, and I've already mentioned that the occupier may restrict or exclude altogether his duty by agreement or otherwise with the visitor. So, and this can happen where occupier posting a notice at the entrance on the premises to the fact that every person enters at his own risk and should have no claim against the occupier. So if you go to some eateries, you see cars are parked at owner's risk. All those things is to limit the liability of the owner of the premises if your car is stolen and all that. So I think on that note, we stop for now, and hopefully by Wednesday we wrap up our discussion. Due to time, I would have loved to take questions again, but due to time, I may not be able to do that. I have to enter housing law class by 11 o'clock. So, class, on that note, we see on Wednesday, and I would advise that please prepare for our test on that day. I will tell you the modality. I will just encourage you that ensure that your camera, you have a good internet. You have a good internet. I'm likely to send you an email that once you have done with your test, you just sign off. You send to the email, and that's the end. Okay, so good day.
Thank you, sir.
All right.
Thank you, sir.
Thank you, sir.
Thank you, sir.